Okay, everybody, take number 17,452. This is Vinny Maletti with Maletti Law, the strongest name in law. And I don't know what date it is anymore because I've done this video now so many times, but I'm attempting to do a part 2 to the video from this morning having to do with our class action litigation situation that we're talking about. Remember from this morning's conversation, we introduced what it is to, why they're class actions, where you see them, what their significance are, whatever the case is, the 4 elements of a class action. It was, you can get class action certified under Rule 23A. One, that the class that you're looking to represent has to be so numerous that joining all the members is impractical. 2, that there are questions, law, and fact common to all the members of class. 3, that the claims and defenses of the representative plaintiffs are typical of the rest of the members in the class. And number 4, that the representative plaintiffs, the person bringing the claim, will fairly and adequately represent the interest of the class. So I spoke very fast, and for my content writer, this is going to be a very challenging video for you. But I will try my best to slow down when I speak on this. I'm just, I just did this a couple of times right now, so I'm a little frustrated that I'm taking so many times to do this video. Okay, so the purpose of this part of the video this morning, the first video, we spoke about the 4 elements of a class action, right? And, how you could seek certification, why you would want to seek certification, and the implications. This video is going to discuss how you can challenge their attempt to have a class action certification. Now, as a preliminary note, each federal circuit is different, right? So the Second Circuit, which encompasses New York and Connecticut, is a very different circuit than which encompasses, Illinois, which is the Third Circuit, and they treat things a lot differently. So, just keep in mind that each circuit has their own rules and laws, and I hope you go to your attorney, which I hope it's me, and, you'll discuss this with them to determine this little nuances and everything. So, but generally speaking, you can attack from a class action certification or a request to have a class action certification on the front end, which is what's known as a motion to strike. You would file a motion to strike at any point, let's say, either with the answer or subsequent to the answer. I would do it with the answer. I would have everything packaged in one and do it with the answer. That's how I would do it. But you could always do it at another date and time, get a little discovery in there, and then you can file your motion to strike. Whatever you need, it's flexible. You can do what you want to do. Motions are what? They're like $75 or $45 or some nonsense to file. So who cares, right? Whatever. Okay, so your 4 defense. So right now I'll tell you 4 ways how you could challenge these motions to strike, and basically you challenge them in the same kind of fashion that which you would introduce them, right? So remember we had our 4 elements of a class action. Therefore, you have 4 challenges of a class action, right? So the first challenge, you would challenge the numerosity requirement, which is Rule 23A1. So remember, the class has to be numerous, right? So each jurisdiction is different. Generally, in the Second Circuit, if you're under 25 plaintiffs, if you're under 25 members of the purported class, you could challenge our numerosity, that it's not sufficiently numerous for your purposes. If you have between 25 and 40 members, that's like a little iffy question. You could fight about it. The court's going to err on the side of, wanting to grant certification, or at least giving the plaintiff the opportunity to bring their certification. If you have over 40 plaintiffs, you're likely going to get that numerosity requirement, so don't worry about it. Then if that situation, as a defense attorney, you'll attack it anyway. You probably won't be successful, but you try anyway because you leave no stone unturned. All right, so the second challenge, once you determine whether or not the numerosity is a real thing, second challenge is going to be the commonality. So there needs to be, this is known as a similarly situated situation. Similarly situated class members. Basically, they all kind of need, there needs to be these common laws and facts amongst all class members, including the representative, right? So I've been using a wage an hour all day, so let's say discrimination, right? Just to switch it up. Law and fact common to it. All these members are African American. All these members were discriminated against. All these members suffer from discrimination. That's the commonality requirement. That's under Rule 23A2. If some, let's say, are asserting that they were discriminated against based on age, some would asserting that they were discriminated against based on race, then they're not common. They're not. They lose. They fall outside of the commonality requirement. So then they're not a class. So the commonality requirement is really asking the question, whether that there are questions of law or fact that are common to the class that you're purporting to represent. All right. So then the third challenge is going to be challenged challenges typicality, right? So in this one, basically we're saying here that the person who is the representative party who's looking to bring this class has to have the same kind of has to be able to represent the same kind of claims and defenses that the remainder of the class would be. So, you know, I was using earlier today wage and hour. I'm going to just use discrimination. I'll just throw it off a little bit. The representative of the class is African American. Wants to bring a complaint that says you discriminate against all African Americans, whatever the case is, right? Class action. As you go through the claim, you find out that some of them aren't African American, some of the class members are over 40, some of the class members are different races, some of the class members have different situations, so that representative does not have the requisite typicality that they need to represent the class. The court may want to break it up depending on, you know, how many people there are. The court may want to modify something. The court may just say, no, you can't have a class. You know, you're too erratic, that you're not typical. So that's the third element. Third element is a challenge to typicality. The fourth element is called challenges to adequacy. This is the situation in where you find conflicts. So in order to bring a claim for a class action, okay, the representative bringing it doesn't need to not only have the same law and facts, kind of like the law and facts as everybody else, will have the same claims and defenses as everybody else in the class, but the person who serves as the representing plaintiff of the class needs to have adequacy throughout the life of the claim, okay? So let's put it, so now this is where, let's just say, you know, this is where, let's just say, a wage and hour claim would be very helpful. Bob starts working for an employer, non-exempt. Bob at some point becomes a manager, exempt. Bob works as a manager for 3 years, employs other non-exempt people before him. They wind up becoming exempt at some point as well during their career. Bob says, I want to represent everybody, all employees from 6 years prior. Well, the problem is that Bob is representing employees that are no longer adequate for the class. So Bob is saying, okay, all these people are non-exempt employees for the past 6 years. But that's not the case. They're not non-exempt employees for the past 6 years. So they're no longer adequate. Bob himself is no longer adequate because Bob at some point has now become an exempt employee because now Bob's a manager himself. So there's no adequacy because Bob now, he's in a different situation, and that different situation is going to tear away at the class action certification. So Bob is never adequate to begin with, right? So that's basically what we mean by challenges to adequacy. That's, you know, under Rule 23A4, basically we're saying here that this person is not going to be an adequate plaintiff, at least at some point in the claim down the road, not going to be an adequate class, at least some point down the road, something's not going to be adequate, something's going to fall out of that class, fall out of typicality, and it's going to eat away and detract at the class action. And why is this a problem? This is a problem because the courts don't want to be bothered. Class actions are not for you. They're not for the plaintiff. I mean, the law will tell you, oh, it's for, you know, if it would be unduly burdensome for the plaintiff. No, it's for the courts. They need judicial, what's known as efficiency. They need to know that they can efficiently manage these claims one by one, or whatever the case is, handle them all as a group, and get out of there and not waste resources, not waste judges' times. People have frivolous lawsuits all day long, nonstop, and they want to do whatever they can to make it as easy as possible for themselves. So this is one of the ways to do it. So with that in mind, those are your 4 ways to challenge your class action. You know, if someone's filing a motion to get class action certified and they want to challenge it, this is your 4 ways to do it. You know, just to repeat them. First way to do it, challenge numerosity. Second way to do it, challenge the commonality. Eat away at the similarly situated representative or class. Part 3, challenges typicality. Show how the plaintiff, the representative person, is not typical of the class. And step 4, challenges to adequacy. Show that the class is not an adequate class, show that the representative is not an adequate representative, or at least at some point won't be, and they will wind up causing damage and wasting time to the class. And that's the best way to approach these things. Keep in mind, like I had mentioned before, the Second Circuit wants you to really go through the motions. Other circuits will let you do this up front. So, you know, make sure you consult with your attorney, determine what's going to wind up happening. You always should take I would even caution you, not doing this is not good. You should always fight, always. Never just accept Never just accept the defeat. If you get a bad ruling, you get a bad ruling. If you get a good ruling, you get a good ruling. But you know what, though? I'll tell you right now, you don't get any ruling if you don't try. So, that is my advice to you here. So this has been, the 4 challenges to class certification. And, as I said before, please subscribe below, sign up to the newsletter. I hope this video was informative. It only took 400 attempts to do it because apparently every time I'm trying to do it, some more chaos is ensuing in the world around me. So this is because my car also serves as my studio. So yours and laws love lifts. If you have any questions, you know where I am. Leave them in the comments below. Go to the website. Feel free to write me an email. Feel free to drop me a credit card and give me a retainer. Whatever the case is, I'm here. Have a beautiful day, everybody.